Hi everyone. To understand the difference between latent and patent defects in a property, stay tuned because in this episode of Property Talk, that is exactly what we're going to cover.
Hello and welcome to Property Talk, where we share all sorts of information to help you master the property game. I'm Lucy Blackman.
And I'm Gerard Robinson, and today we're covering latent and patent defects.
But before we get started, please hit the subscribe button below and click on the little bell to be notified when we upload new videos. For previous episodes, click on the little eye on the top right-hand corner of your screen, and we'll leave a link in the description box below. Let's jump right in. Sellers are obliged to disclose known defects about their home, and they may not conceal them from potential buyers. While some defects may not be easily visible, they can affect the value of your property or the buyer's decision to buy it. Estate agents are also obliged to disclose known defects to potential buyers.
There are two types of defects, latent defects and patent defects. Latent defects are those faults that are not easily discovered by reasonable inspection, such as a foundation instability, roof problems, plumbing issues, swimming pool leaks. Patent defects, on the other hand, are visible to the naked eye and easily discovered by a reasonable inspection, rather like those shiny patent leather shoes which are difficult to miss.
Buyers must do due diligence and carefully inspect the property because the term caveat emptor applies. This means let the buyer beware. Many buyers believe that they are protected by the Consumer Protection Act, but this legislation only applies to sellers who regularly or continually sell property, such as property developers. But the Consumer Protection Act does apply to estate agents. A buyer can claim damages against an agent under the Consumer Protection Act if he can prove that the agent was aware of the fault and intentionally withheld the information. If the Consumer Protection Act does not apply, then the Voetstoots clause, meaning as it is, protects the seller to a degree, unless the seller was aware of the defects and did not disclose them. Many sellers believe that Voetstoots absolves them of all responsibility because the property is sold as it is, but the courts often find otherwise.
Good practice is to list all known defects in the sales agreement. The buyer is then aware of them and cannot claim damages on the grounds of concealment. Also add a list of any defects that the seller agrees to repair before transfer. This protects the buyer against the Voetstoots clause. So sellers, accurate and honest disclosure is the best policy, and buyers, do your due diligence.
That's it from us for today. Until next time. If you've enjoyed this video and found it informative, let us know in the comments section below. We'd love to hear from you. Remember to like our video and to subscribe if you haven't done so already. Follow us on Facebook by clicking on the link in the description box below. Visit our website, stjohnsvillage.co.za, and please share this with anyone you know who may be interested in buying or selling property.